In this presentation, we will discuss the extent of Congress's power to create an independent agency structure that limits district court jurisdiction over agency decisions and provides dual-layer protection for administrative law judges. So, over the last century, Congress has established an array of executive agencies that are partially isolated from presidential oversight that wield tremendous enforcement power in the areas that they control. But instead of filing lawsuits in federal court, these executive agencies can commence their own administrative enforcement proceedings against companies and individuals and make their cases before their own administrative law judges. And not surprisingly, administrative law judges overwhelmingly rule for their own agencies. And you should note the criticisms directed at arbitration can be relevantly paralleled to administrative law judges as well. The relevant constitutional powers you need to keep in mind during this presentation are Congress's power to create administrative agencies and the subsequent authority of the agencies created, Congress's Article 3 powers to hear cases or controversies, and due process rights. The constitutionality of the existence of these agencies and their provisions does not rest on simply one part of the Constitution, as there is a real and palpable concern about the separation of powers and whether independent administrative hearings that can preclude district court jurisdiction overstep the bounds of what Congress can create, what the executive branch can do, and what limitations can be placed on the courts. Now, the standard procedural development for an independent agency structure case follows usually as such. Congress has passed a federal act, and there's a federal administrative agency structure that covers the provisions of that act, and an action is undertaken by an entity other than the administrative agency, which then prompts the agency to file an administrative complaint against that other entity based on their authority to enforce certain behavior under the federal act. This other entity wants to adjudicate that dispute in district court and have their case heard in front of a judge, but the administrative agency wants to adjudicate the dispute by administrative proceedings in front of their own administrative law judges, who again frequently will rule in favor of the administration. So, under our first trilogy case, Thunder Basin, Congress had passed a federal act, the Federal Mine Safety and Health Amendments Act, which prevented a district court from exercising jurisdiction over a pre-enforcement challenge to the statute. Thunder Basin argued that forcing the company to challenge the act through the administrative courts before adjudicating in a district court violated due process. But the court ultimately decided that there was a valid preclusion of district court authority to hear the case because, first, Congress intended to preclude the district court jurisdiction based on the Mine Act's detailed structure for reviewing violations that could be later subject to review by a federal court of appeals. And the court also determined that the claims were of the type that Congress intended to be reviewed within that Act's statutory scheme. The second case in this trilogy, Free Enterprise, features the Sarbanes-Oxley Act, which authorized the Security and Exchange Commission to create the Public Company Oversight Board that could independently do audits of companies to protect its investors. And an accounting firm was sued after this board released a report that was critical of the firm's auditing procedures and began a formal investigation. And the accounting firm wanted a declaratory judgment that the board's structure violated separation of powers, which the court determined it did, because unlike in Thunder Basin, the board's report could not be reviewed by an appellate court, so the only way the firm could raise a constitutional claim under the statutory scheme was to either challenge a random board rule or willingly incur a board sanction by violating a discovery order. So the statutory scheme could not possibly provide meaningful judicial review because there was no way for a redress of grievances under the normal procedures of the statutory scheme. And the court also concluded that the constitutional claims were outside of the Security and Exchange Commission's expertise because they were standard questions of administrative law rather than technical considerations of agency policy. And in the final case in our trilogy, Elgin versus the Department of Treasury, which involves the Civil Service Reform Act, the Supreme Court held in 2012 that an employee challenging his removal from the civil service must pursue his claim before the Merit Systems Protection Board and later seek judicial review in the Federal Court of Appeals after the administrative provision is done, even if the basis for the employee's claim is that the statute under which he was removed is facially unconstitutional. So even though the court has developed a multi-factor test from Thunder Basin and Free Enterprise, the fact that there is an opportunity for meaningful judicial review by an Article III court that is fully competent to adjudicate the petitioner's claims is enough to uphold the statutory scheme. This case trilogy has left us a constitutional analysis for Axon Enterprise versus Federal Trade Commission, which Chris will take up next. And under the first step, we look at whether the Federal Act's statutory scheme is designed to preclude federal court jurisdiction. And if it's not, then the entity subject to the administrative claim may have the claim adjudicated in a federal district court rather than the agency's administrative proceeding. But if the scheme is designed to preclude federal court jurisdiction, then we proceed to step 2 and see if the Thunder Basin factors are satisfied. And we look at whether the claims brought by the agency are intended to be reviewed within that statutory scheme such that the district court's jurisdiction is precluded until the administrative proceeding is finalized, meaning that the entity subject to the complaint could not have their day in court until the administrative proceeding was done, and then could bring suit in federal court. And so first we look at whether a party subject to the administrative complaint can obtain meaningful judicial review after the administrative proceeding is decided. Then second, we look at if the agency's complaint is wholly collateral to the Federal Act's statutory scheme, and if the claim is the procedural vehicle that a party is using to reverse the agency action, it is not wholly collateral to the statutory scheme. And then finally, we look at whether the agency's claims are within its expertise. And to be within an agency's expertise, the claims must involve technical considerations of agency policy rather than standard questions of administrative law.
So the current Supreme Court case we're going to be talking about is Axon Enterprises versus the FTC. This came out of the Ninth Circuit Court of Appeals, was decided in January of this year. The plaintiff is Axon Enterprises, which is a company that sells technology, namely body cameras and software, to police departments. And the defendant here is the Federal Trade Commission, which is a government entity established to regulate trade and prevent unfair trade practices. Here they're exercising their ability to investigate and punish violations of the antitrust laws. And then prior to this decision in the Ninth Circuit Court of Appeals, the U.S. District Court for the state of Arizona dismissed it for a lack of subject matter jurisdiction. So some of the relevant facts from this case: in May of 2018, Axon acquired one of its competitors, a company called Vivu. And in June of that year, the FTC initiated an antitrust investigation into the acquisition. Axon had cooperated with the investigation and claimed that they spent more than $1.6 million responding to FTC investigation. After that, the FTC gave them a choice between rescinding the acquisition, paying a sum of money, and transferring some intellectual property to Vivu, which would end up making Vivu essentially equal to Axon, which was not the case before the acquisition. Or the FTC would go ahead and proceed with the administrative complaint against them. Axon filed suit in the district court against the FTC to enjoin the administrative proceeding, and the FTC that same day filed their administrative complaint. They also filed an answer to Axon's complaint, which stated that the district court did not have jurisdiction over the claims. So in its complaint, Axon made 3 primary claims, the first of which being that the FTC's administrative proceeding is violating Axon's due process rights because in these proceedings, the FTC is acting as the prosecutor, the judge, and the jury. The second claim is that the actual structure of the FTC violates Article 2 and the Appointments Clause by providing improper insulation from the president, because only the FTC commissioners can actually remove the administrative law judges for cause. And then third, which is not a constitutional claim. Axon simply claimed that their acquisition of VIEVU did not actually violate any antitrust laws. The first question that the court addresses is whether it's fairly discernible from the FTC Act that Congress intended to preclude the jurisdiction of the district courts over Axon's claims. And the circuit court basically says that because it's very detailed, the FTC Act is very detailed, it has a detailed scheme of how the FTC can issue complaints, carry out administrative proceedings, and how a defendant can proceed into the appeals process. It does reflect a fairly discernible intent to preclude the district court jurisdiction. The next question the court has to decide is whether Axon's claims are the type which are meant to be reviewed within the statutory scheme of the FTC Act. This involves a consideration of the three Thunder Basin factors, whether there's a chance for meaningful review, whether the complaint is wholly collateral, and whether the claims are within the agency's expertise. And the court stated that previous courts have held that the first factor is to be weighed the most heavily. So the first one of these Thunder Basin factors that the court discusses is whether the plaintiff can obtain meaningful judicial review from the statutory scheme. And Axon is essentially claiming that there is no meaningful judicial review because the review process creates constitutional harms which cannot be remedied by appeal. And the court basically says that that's not true. Even if there are harms that are created by Axon having to go through this process, they can be remedied by the federal appellate court after the administrative proceeding has gone through. And the other claim is that there's no meaningful judicial review because the administrative process cannot address constitutional concerns. And the court says, while that's true, it doesn't really matter because that would be the case in any type of judicial administrative proceeding. And again, they reiterate that if Axon goes through the administrative process and then proceeds to the federal appeals court, they will be able to provide meaningful judicial review to the constitutional claims. So they essentially hold here that there is meaningful judicial review. So the next question is whether the claims are wholly collateral to the statute's review provisions. And a claim is not wholly collateral if it's been raised in response to and if it's intertwined with the administrative proceeding. And the Ninth Court basically said that because this is the way that Axon is seeking to get around the agency process, because they're seeking injunctive relief, that the claims are not wholly collateral to the statutory scheme. So here, this factor, the court is discussing whether the claims are outside of the agency's expertise. And basically, if the claim is not involving technical consideration of agency policy, then the claim is going to be outside of the agency's expertise. And the Ninth Circuit says that due process and appointments clause, they're not part of the merits of the antitrust case. And so there's nothing really here for the FTC to apply its expertise to. Therefore, this weighs against preclusion. So overall, essentially what the Ninth Circuit ends up holding here is that the Supreme Court precedent that's coming out of these trilogy cases is just going to force them to preclude jurisdiction of the district court over the claims that Axon is raising. Essentially because Axon can get meaningful judicial review through the appeals process, but in order to do that, it's going to have to go through the administrative process first. And in their opinion, the court does say that Axon does have some valid claims, it believes, and that it believes that there are constitutional issues that need to be dealt with here, but they're going to have to go through that administrative process before, and the court can't take up those claims before they do that.
Now we must make a determination on whether or not the Supreme Court will find for and affirm the Ninth Circuit's holding. To do this, we have to go back to the issue at hand, whether the Thunder Basin factors allow administrative agencies to subvert district courts' jurisdiction to hear pre-enforcement constitutional challenges pertaining to agency structures. So, to determine what the likely outcome of the Supreme Court's decision will be, we must once again analyze the case, but through the perspective of the Supreme Court. Based on the Supreme Court precedent, it is likely that the Supreme Court will affirm the lower court's holding. The first element on whether the intent to preclude district court jurisdiction is fairly discernible is satisfied because 1. Axon concedes that the FTC Act impliedly precludes jurisdiction for at least some of its claims. And two, the lower court also found that the structure of the FTC Act includes a detailed overview of how the FTC can issue complaints and carry out administrative proceedings, a revision fairly similar to the SEC Act, which has been used in prior courts to show a fairly discernible intent. Thus, once again, it is likely that the Supreme Court will find that the first element is satisfied. The larger issue here is whether the Supreme Court will find that the next element is satisfied. Precedent has shown that the Supreme Court tends to apply the Thunder Basin factors in its analysis of this element. On the meaningful judicial review factor, Supreme Court precedent has determined that as long as the challenging party has the opportunity to an eventual review on its statutory and constitutional claims by the appellate federal court, then there is meaningful judicial review. In this case, the lower court has stated that Axon could appeal the administrative law judge's decision and possible harm could be remedied in a federal appellate court, thus satisfying the element. The second factor, the wholly collateral factor, is also likely to be satisfied. In Elgin, the Supreme Court analyzed the wholly collateral factor in a procedural sense, meaning if the claim is the procedural vehicle that the party is using to reverse the agency action, it is not wholly collateral to the review scheme. Since Axon seeks to prevent the FTC from pursuing its administrative enforcement action, the claims are therefore the vehicle by which Axon seeks to prevail at the agency level, and thus is not wholly collateral to the review scheme. Lastly, the third factor requires a deeper analysis, as the Supreme Court has made it more ambiguous in comparison to the other factors. Like was stated a few slides ago, the lower court found that the third factor weighs against preclusion. However, the Supreme Court precedent has affirmed similar decisions by addressing only 2 out of 3 of the factors. It is likely that the Supreme Court does not make it necessary for all 3 factors to strictly satisfy. Thus, it is likely that in this case, it will be the same, and the Supreme Court will affirm the lower court's decision. Is this the appropriate resolution? Well, ultimately, the decision on this case will lead to a few policy concerns, and the overarching concern is whether or not the structure of the FTC as investigator, prosecutor, and judge in its own cases complies with the Constitution. Has Congress given the FTC and administrative law judges too much power to be constitutional? On the affirmative side, allowing this decision minimizes businesses' ability to avoid administrative proceedings or to avoid procedural responsibility by using the holdings of the district court as an excuse. But on the negative, this may seem like way too much delegated power, which leads to a question on the separation of powers. On another front, the FTC has stacked the deck in its favor in its administrative proceedings, meaning that it tends to win all of its cases. In a quote stated by the dissent, acknowledged by the majority, and referenced in many scholarly articles, it makes little sense to force a party to undergo a burdensome administrative proceeding to raise a constitutional challenge against the agency's structure before it can seek review from the Court of Appeals. There is a chance that businesses may not even reach the Court of Appeals for review. Administrative proceedings can last years and cost a lot of money, leading a business to prefer settlements over appeals. As that affects due process, it seems to be a huge constitutional concern. We will have to wait and see what the Supreme Court decides in the future, but as of now, Supreme Court precedent lends itself to agree with the Ninth Circuit's decision.